So on such basis, we now proceed to the second issue, that is the first steps taken by the arbitral tribunal. In order to conduct the arbitration fairly and efficiently, what are the first steps that the arbitral tribunal should make upon its formation and upon receiving the case files from the parties or from the secretariat if there is an institution involved? So generally speaking, upon formation and upon receiving the case files, the arbitral tribunal should be responsible for running the proceeding and going forward, deciding procedure and substantive issues in that case. In ad hoc arbitration, where uncentral rules are adopted, there is no standing institution to receive the case or to provide administrative services. These are all handled by the arbitral tribunal upon its formation. And in these cases, the arbitral tribunal undertakes a heavier administrative role than those in institutional arbitration. It should be noted that some institutions, they also provide services in support of ad hoc arbitration, such as appointment of arbitrators or holding of funds for the whole duration of the arbitration proceeding. In institutional arbitration, where institution arbitration rules are adopted, the secretariat will still get involved throughout the proceeding, even after the tribunal has been formed. And depending on the specific arbitration rules, and also depending on the different legal background of that institution and their culture, the role and function of the secretariat may include, for instance, to monitor the process to ensure that the conduct of the arbitration is in line with the arbitration rules, or to guide the arbitrators in their conduct of the arbitration in terms of procedural management, or to serve as a transfer station of files, letters, and submissions between the parties and the arbitral tribunal. Now, let's come to look at what the rules say about the first steps taken by the arbitral tribunal. The uncentral rules provide in Article 17, paragraph 2, that as soon as practicable after its constitution and after inviting the parties to express their views, the arbitral tribunal shall establish the provisional timetable of the arbitration, and they may change the timetable afterwards upon consultation of the parties. So establishing provisional timetable is indeed a priority of the arbitral tribunal, because only after this the parties would know and they could reasonably expect which submission is due by which date, when would be the hearing, and how many rounds of submissions they would be entitled to in this arbitration. So we could say that the provisional timetable is basically an agreed roadmap with marked dates for specific action by a specific party or parties or the entire participants of the arbitration. The issue of provisional timetable will be dealt with in more extensively by Ms. Nakahara later.